Prepare to take up the case of Summers versus the United States of America.
Thank you, Mr. Chief Justice. May it please the Court. My name is Megan Salant, and I am an Assistant Federal Defender in the Northern District of Florida. I represent Mr. Summers in the 11th Circuit Court of Appeals. The 11th Circuit has certified 2 questions to this Court regarding Florida's simple assault statute. As to the first question, whether the first element of the offense requires a specific intent, all of the parties are in agreement that it does not. The statute creates a general intent crime. The only issue that remains in contention is what mens rea is required to prove the first element of simple assault. The first element of Florida's simple assault statute requires a voluntary act where the actor consciously disregards a substantial certainty that the victim may feel threatened. Simple assault can be committed recklessly. In Florida, recklessness is referred to as culpable negligence or evincing reckless disregard of human life or the safety of others. Reckless behavior under Florida law is not merely voluntary behavior. It contains a component of knowledge. It is just not the heightened knowledge needed for the higher culpability standards of knowledge or purposeful. This Court is consistent.
Counsel, I'd like for you to focus on the text of the assault statute.
Sure.
Which requires an intentional, unlawful threat by word or act to do violence to the person of another. Now, what does threat mean?
Well, threat has not been defined as it's
What's the
used.
common understanding of the word threat?
I would say it is a communication that is substantially likely to put the victim in fear or the
Well,
listener in fear.
that's something I think you made up. Because if you look it up in the dictionary, it says something rather different. It says it is a communication, a communicated intent to inflict harm. That's one dictionary. Or it says a declaration of an intention to take some hostile action, especially a declaration of an intention to inflict pain, injury, damage. So built into that word threat, there is this notion of intent in its common understanding. Isn't that correct?
Correct. But what we are arguing is that that notion of intent is not as high as the knowing or purposeful standards of culpability. And that was established by the U.S. Supreme Court in Alonis. They made it clear that the definition of threat, according to the U.S. Supreme Court, does not necessarily exclude recklessness.
Well, okay, but what I think I'm hearing in the Chief's question is not like a gradient question, it's a round peg, square hole kind of thing. So to be reckless is to know a risk and disregard it.
Correct.
That seems different in kind, not in degree, from making unintentional communication. So I don't think, while I understand that mens rea operates and can be organized on a gradient, I think what you're hearing from the Chief's question, what you're hearing from me, is that it's hard to see how recklessness, which is about knowing and disregarding a risk, is compatible with the definition of the word threat, which is to make a communication of some kind. It isn't about ignoring a risk or being cavalier in the face of a risk. It's about making a communication. And for your theory to work, I have to make that communication recklessly, which doesn't seem to fit. Can you help me understand? What am I missing?
Well, I think that, so the example that I have found is in a crowded parking lot, if like an event ends and somebody goes to get out of that crowded parking lot and completely disregards the fact that that it is a crowded parking lot, and instead veers or screeches out of their parking space and puts all of those people, affects all of the people who are in that parking lot, all the pedestrians. That person is putting those people in fear. And when you read the statute as a whole, when you read it together with the third element.
What was the threat there?
that they were going to get hit by the car.
Well, no. But what threat did the defendant? I understand, but I guess to push back on your hypo just a little bit.
Sure.
Help me understand how that conduct is similar to the conduct in this case, in that here I think the defendant engaged in threatening behavior with a victim in mind. I'm not sure that what you're talking about is what I would charge or what they would charge as an aggravated assault, right?
Well, first of all, in my case, we're not looking at the facts of Mr. Summers' aggravated assault. We're only here to consider the statutory elements.
I got it, but I'm responding to what you're giving me as something that makes your definition of threat work, and my response is I don't think it works.
Okay. Well, I believe that when you read the statute as a whole and you realize that there is a very strong victim component in the third element.
But that's just a separate element. I mean, it is true that is there, but that's a separate element that has to be satisfied in addition to the threat element.
Sure. And our argument is that the threat has to be an intentional act that would put the victim in fear.
So, counsel, under your sort of theory here, and following up on Justice Coriel's hypo, if someone was driving recklessly, and there was no doubt it was reckless driving, which is its own crime.
Correct.
And someone was in fear that they were going to be harmed through that reckless driving, could that person also be charged with aggravated assault with a deadly weapon?
Yes. Okay. So I also think that
Let me ask you this, and this is, I don't think anybody's thought about this, but we have a statutory rule of lenity in our criminal code, and it says the provisions of this code and offenses defined by other statutes shall be strictly construed. When the language is susceptible of differing constructions, it shall be construed most favorably to the accused. Now, I understand this is kind of an odd situation. It's kind of like we have a role reversal here, but obviously we have to look at this from the perspective of a prosecution for this offense.
Sure.
And I just don't understand any way that there's not an interpretation, a reasonable interpretation of that offense, which is going to require that there be a direction of a threat at a particular person, which is what is required, if I understand Borden correctly. Is that consistent? I mean, because all of this, we talk about specific intent, general intent, all that. Borden didn't talk about that, did they? I mean, they didn't talk about specific intent.
No.
So tell me this: what are we looking for under Borden? What do we need under Borden?
Well, I would propose that you don't need anything under Borden, because the point of this is for you to decide what the Florida law, how the Florida law applies.
But the question is, how does that fit within the Borden framework? That obviously is the question that the 11th Circuit wants us to address.
Well, of
they
course.
aren't concerned about how the particular terminology that we use in Florida law. That's, because in this context of the law, these terms are used in different ways in different places, and it's kind of a quagmire. But so you don't think we really have to figure out how this fits, how our statute fits within the framework under Borden?
Well, I think the 11th Circuit has asked you to identify what the mens rea is for this offense, and if they knew if they could clearly tell from the case law and the statute what that was under federal law, then they wouldn't have asked you to address it. But I do believe that.
Well, I understand it's a question of state law that we need to address, but it's a question of how the state law fits within the framework under Borden. Or am I entirely missing something when I think that?
No, that's correct. I think that under Borden, what you would need to decide is whether or not this is an offense that can be committed recklessly.
Okay.
That is the language that Borden uses, and that is sort of the bright line rule that Borden established. So, and I think that this court has said again and again that a reckless violation of another's rights is actually an intentional violation, It said that in Cannon, Preston, Savage. There's a number of cases where this court has held that. And what they're protecting against, what it seems to be protected against with this statute is the public's right to not be in fear, to not be, worried that at any moment someone's going to pop off with a gun or back into them with their car or something like that. And since this court has said that sort of reckless violation is intentional, then I would assert that the assault statute is a reckless statute. The simple assault statute, excuse me.
Let me ask you just a question. Something that I observed a long time ago when I was a prosecutor. I was watching a trial, and the prosecutor in the case, it was an armed robbery with the use of a firearm. It was a big .357 Magnum. I think it would require both my hands just to pick it up. And it was a very violent robbery. People were pistol whipped and so on and on. The prosecutor, in closing argument, picked up the gun that was in evidence, walked up to the jury, cocked it, and pointed right at the jury, saying, "This is what it feels like to have a gun pointed at you." Obviously, there were all kinds of emotions, but would that qualify under your hypothetical of there having to be some type of intent? Would that be reckless on the part of the prosecutor, or would that qualify as an aggravated assault?
I think that would come down to a question for the jury as to whether or not if that was a reasonable action.
Good answer.
I would certainly have been terrified and
obviously
angry.
Obviously, the jury was
right. Right.
But in this instance, the talking about the mens rea. Obviously, he did not intend. Well, he intended to frighten them, obviously, but not the intent that I think is required for a crime.
Right.
But by the same token, it seems like all the elements of aggravated assault were there.
Correct. I think that, like I said, I think that when it comes down to it, it would have to be a jury question whether or not that was actually a threat. But it doesn't seem reasonable to me.
Well, it didn't work. The guy was acquitted.
Maybe it's because they were mad at the prosecutor. So the DCA cases in Florida here have all have discussed that what's necessary to prove simple assault is actual intent. And the difference between what we're claiming and what the Solicitor General is that what that actual intent is. So we're, like you said, we're taking it as a degree of awareness, that the actual intent is it's a degree lesser than the knowledge and purposeful requirement, which would make it recklessness. And as I said, because
So to agree with you, we would have to decide that this ordinary definition of a communicated intent to inflict harm is not what threat means.
I think that Florida would have to be recognized as an outlier for that in the assault statute. Yes.
So well, I'm not sure. So we'd have to reject that definition.
Yes, I think that we'd have to have the element, the word actually defined by this court in the statute, as it's used in the statute, which we don't have.
But we've got it defined in multiple dictionaries.
Well, and
what I guess my question is, we'd have to reject, to accept your view, we've got to reject the definition that appears in multiple dictionaries.
I think that you don't necessarily have to reject it. There has to be an understanding that the intent is not one of the higher levels of intent. In that definition. It's not the most culpable element. It's not the most culpable mens rea. It is one below that. All right. I'll save the rest of my time for rebuttal. Thank you.
Good morning. May it please the court, my name is Jordan Learn. I'm an assistant United States attorney in the Northern District of Florida, and I'm here on behalf of the United States. We're asking the court to hold that the first element of simple assault in Florida requires a purposeful or knowing threat of violence against another person, and that a reckless threat, a threat made recklessly, is insufficient to trigger culpability under the assault statute. Now, unless there are any...
Let me ask you this. So that makes sense to me when we're talking about a verbal threat, a threat by word. I mean, I don't see how it couldn't be directed at a person and meet the definition of the statute. But what about the threat by action? There are plenty of cases in Florida, probably today, maybe one's being tried, where a suspect is fleeing law enforcement in a vehicle, and there are officers either in a vehicle or on the just standing that are in the way, and they'll jump out of the way. And then if the state believes that that can be it can be proven that there's an intent that's directed at a person, they'll charge attempted murder. With the aggravated battery with a deadly weapon charge, the vehicle being the deadly weapon would be the lesser included offense. But if they don't, they would charge it based on what I would think would be reckless conduct, that it's aggravated assault with a deadly weapon. So how is your statement true when the threat is by act? Isn't it possible that that is reckless?
Sure. No. The answer is no. If it's a reckless threat, then it doesn't qualify as a threat under the statute. The question, I think what your question is focused on, is going to turn on whether or not the defendant is substantially certain that his actions would be perceived as a threat of violence. And so we see this in Swift and Pinckney's very similar factual circumstances. And Swift actually reversed an aggravated assault conviction essentially because there was insufficient evidence that the defendant had insufficient evidence that the defendant could be certain that his action would be perceived in a threatening manner, because he didn't realize that the officer was in his path when he was reversing the vehicle. So it's going to turn on what circumstances do we know the defendant's aware of, and whether or not the defendant is substantially certain that his actions will be perceived as a threat. And that is analogous to knowledge under the Model Penal Code.
But under Borden, aren't we talking about an intent to direct the action at a specific person?
Sure. And so,
and in the hypo that I was using with the car, it isn't possible that they would meet the definition of the statute, aggravated battery or assault with a deadly weapon, without intending to direct that at the specific person.
Our answer would be no. If there's not sufficient evidence that a defendant is substantially certain that his action is going to be perceived by another person as a threat, then that's insufficient evidence of mens rea under the statute. And that's essentially what happened in Swift. There was insufficient evidence of knowledge, and so they reversed that aggravated assault conviction.
So in my example, the prosecutor was definitely reckless.
Sure.
In pointing a .357 Magnum in the jury 3 feet away from them, but he intended to scare them. So where does that fall?
Well, if it's an intentional, if he's acting with purpose, then we would say that certainly qualifies.
So he could have been charged with what, 7 aggravated battery?
Aggravated assaults.
With a firearm, 3-year mandatory minimum each.
Right. I suppose in theory, yes. But I also think if you apply a knowledge standard to that, you're going to get the same answer. If you point a gun at somebody, you can be substantially certain that the person on the receiving end of that gun is going to interpret that action as a threat. And that's all that we're saying the statute requires. So
say I have a gun here and I pick it up, I just recklessly just swing it around and I see everybody out there just bending over. Does that mean I just committed aggravated assault on everyone?
I think that's certainly a tougher question. I think under the reasoning of Pinckney, yes, that could be charged as an aggravated assault, and it would just be a jury question of whether or not you were substantially certain that your action, based on the facts and circumstances in which it occurred, was reasonably likely to constitute, to be perceived as a threat. And that's all that we're saying the standard is. Certainly it meets the standard of reckless. You know, I could see argument both ways, and it'll come down to a factual jury question, but we do think that the plain language of the statute compels at least a minimum standard of knowledge, and that comes from the word intentional. Under well-settled Florida law, intentional means substantially certain. When you act, you are substantially certain that the criminal result will be achieved. And so that's a knowledge standard. It's analogous to knowledge in the model penal code. And when you pair that with threat, the only possible interpretation is that you are acting with substantial certainty that your action, whatever it is going to be perceived by a person as a threat. And we think that's the only interpretation that is consistent with the plain language of the statute. If the Florida legislature wanted to have a recklessness standard in the assault statute, they could do that if they wanted to. Georgia has done it. They wouldn't use the word intentional. They certainly would not say intentional threat. They would say either reckless, which appears in other Florida criminal statutes, or they would use the culpable negligence standard, and it's just not what they've done here. So we really do think this case should begin and end with the plain language of the statute. We think that the first element is clear. It's at least a knowledge. We say purpose or knowledge is what we're asking the court to hold. And that's just because the higher mens rea of purpose includes, if you act knowingly, if you act purposefully, then you've also satisfied the element of knowing under just well-settled principles of criminal law. And I should add that every district court that has actually focused on the language of the first element of Florida assault has agreed with this interpretation. They've applied a standard that's analogous to knowledge, and like I said, they've looked to see whether or not the defendant acted with substantial certainty that his action would either elicit fear or be perceived as a threat. And where they find that evidence lacking, they've reversed the convictions without hesitation.
Let me go to the nonverbal examples that Justice Lawson was talking about. What about you cut somebody off in traffic? You know, one car really cut somebody off in a very abrupt, threatening sort of way. And the driver who has been cut off feels threatened by that. Is that enough?
No, because that's focusing on the victim's perspective. The first element of assault focuses on the defendant's intent and whether or not he was substantially certain that his action would be perceived as a threat. I think there too, if you're just dealing with, sort of aggressive driving, you might also run into issues about whether or not that even meets the definition of a threat. The common definition of a threat is an expression of harmful intent.
What does the defendant have to do in order for it to comply? I mean, flipping them off, is that enough? They flip them off and then cut them off?
No, sure. The state would just have to point to circumstances that would demonstrate the defendant was substantially certain or practically certain that his actions were going to be perceived specifically as a threat.
So that would be enough?
I don't think that would be enough. I mean, it's going to depend on whether or not there's sufficient inference. I don't think aggressive driving would be enough. Different cases will present different circumstances, and there will be things you can point at. But I think you're going to apply a knowledge standard, and it's going to depend on the defendant's knowledge.
When was the last time you drove on the Florida Turnpike?
It's been a while. It's been a while. But we do think a knowledge standard can be imparted meaningfully into the statute. And like I said, even if this court thinks that it would result in anomalous sort of applications, based on things that happen in traffic, you're still obligated to apply the plain language of the statute. We think the plain language of the statute is abundantly clear. The only interpretation that's true to the words the legislature passed is that it's an intentional threat. So that's at least a knowing threat. A reckless threat, if there's insufficient evidence of knowledge, then you haven't committed, and the government can't prove it, then you haven't committed an assault under Florida law. I'm sure there's other things that could fill that void, but it's not an assault. And so, unless the court has any other questions, again, we're asking simply for the court to hold that an assault in Florida requires at least a knowing or purposeful threat of violence directed at a person, because that's what Borden and that's what the 11th Circuit cares about. We think that's plain from the language of the first element in the statute, and that is simply that a threat committed recklessly is just insufficient as proof for culpability under the statute. Thank you.
Mr. Chief Justice, and may it please the court, if the court has no questions on the first certified question, I think the case then comes down to, is this a purpose crime or a purpose and knowing crime? And in the state's view, it's the latter. The word intentional, when the legislature used that phrase in 1974, according to Professor Lefebvre, was well accepted to mean both the purpose to accomplish the prohibited act as well as the knowledge that the result would be substantially certain to result. And so we think as the legislature used that term in the mid-70s, it encompassed both of those concepts. It did not encompass recklessness. So further support for that idea comes from the U.S. Supreme Court's decision in U.S. Gypsum Co., where the court explained that purpose and knowledge are encompassed by the idea of intent. And the reason for that is because whether it's your conscious objective to achieve a prohibited result, or you simply know that it's a substantial certainty that the result will occur, you've acted wrongfully in the eyes of the law, and so it's fair to penalize that individual.
So the purpose you're talking about, the purpose is to place the person in fear. That's the purpose of the act.
I'm not sure that would be the purpose. The purpose would be to convey a threat, which, as the Chief Justice pointed out, would be defined as a communicated intent to threaten. But I'm not sure that you actually have to have any kind of specific intent to put the person in fear. It would be enough if you had as your objective the purpose to make a threat. I think there is a distinction there.
If jokingly pointing a gun at somebody, you may think you're joking, but the victim doesn't think you're joking. Where is the purpose there?
So the purpose there is the communication of the intent to threaten, and I think that's what's required. In any event, though, under our view of the mens rea here, that kind of threat would be covered because either it was your purpose to communicate the threat to do violence, or you knew that it was substantially certain to result. Now, in your example earlier with the prosecutor in front of the jury with the firearm, the answer there might be that there is no ultimate liability either because there's not a well-founded fear or because...
Spoken like a true prosecutor.
Well, I mean, it may be that in the confines of the courtroom, it's not well-founded for members of the jury to believe that that's a communicated intent to threaten. So that may be the answer to the hypothetical. But in any event, we don't believe that recklessness rises to the level here. And I would point the court to pages 10 through 13 of Mr. Summers' reply brief, because the way in which he articulates the mens rea that he thinks applies to the intentional threat prong, we just view that as being knowledge, at least as articulated by Florida law and the Model Penal Code. So when you talk about a substantial and unjustified risk, all the commentators in courts have said that that's a recklessness standard. It's about risk. But when you talk about certainty, which is the way that Mr. Summers himself defines the mens rea here, a substantial certainty or a practical certainty, we think those are synonymous. When you talk about a certainty, that's a knowledge standard. I'm happy to answer any additional questions the court may have. Thanks for your time.
Rebuttal.
All right. So just to respond to a few of the points made by each of the governments. I think one thing that seems confusing is that the definition that the Chief Justice identified has the word intent in it, and then the statute also has the word intent in it, or it has the word intentional. And I just want to make clear that word intentional in the statute, as the courts have identified, does not link to the word intent in the threat definition that the Chief Justice read. That just determines that it is a voluntary act, one that is being doing deliberately. It distinguishes it from, as many of the cases have said, it distinguishes it from being strict liability or something that somebody does involuntarily. Also, to point out, I just want to point out, in Borden, it was only the plurality that said that the threat was a use of physical force against another. It wasn't the majority. Justice Thomas dissented on that point, and his analysis, where he did join the plurality, but he did not join the majority. He said he was focusing on whether or not the use of physical force, has a well-understood meaning applying only to the intentional acts designed to cause harm. So he was not saying that he did not agree that the definition of threat included that it had to be purposely targeted towards another person. I think it's also important to note that the elements of simple assault have not changed over time. They didn't change. They were the same. The court identified them as the same before codification and after codification. And as old as the Peterson case from 1889, this court identified that that the aggravated assault conviction could be upheld because there was clear evidence that the defendant acted deliberately and recklessly. So that definition has carried on. And if there are no other questions, that's all I have. Thank you.
All right. We thank all three of you for your arguments in this very interesting case. And the court will now be in recess for about 10 minutes before we take up the last case on today's docket.
All right.